So how is estate administration handled if someone dies without a will? It's Nancy Beauvert here with Agape and NEXsteps. And in this video and for the next few videos, what I'm going to do is I'm going to present some solutions to questions that some of you have sent in about various aspects of legacy and lifestyle planning and estate administration. Today the topic that I wanted to talk about is what happens when someone dies without a will. Now many of you have probably heard the phrase dying intestate. What that means, that's a legal term for dying without a will. That creates a lot of confusion, a lot of stress, and a lot of expense for the beneficiaries and the heirs of an estate. Now, I do want to make sure that all of you understand that intestacy laws can change depending on your jurisdiction, but they basically follow a similar type of flow here. So if you die without a will, what happens is that the courts in your jurisdiction will then be responsible for handling everything. If you do have a surviving spouse or a child, typically what will happen is that person will apply to the courts to become the executor of the estate. But what that means is that the individual that is going to take on that responsibility has to actually go through a process and file legal papers that have to be presented to the court, and they have to be approved, which obviously costs money and costs time. If nobody does step up to become the executor of the estate, then typically what happens is the jurisdiction will appoint a public guardian and they will manage the estate. So what happens once the courts have approved the executor for somebody who had died intestate is very similar to what everybody else has to do. You have to secure the assets of the deceased individual. You have to make sure that things are taken care of. You have to pay debts. You have to make sure that taxes are filed and that all current, past, and present taxes are paid on anything coming out of the estate. All of that has to be done just like in every other estate prior to the disbursement of any of the assets. Once all of that has been done, then you can distribute the proceeds of the estate according to the laws in your jurisdiction. But if you haven't planned, some of the other complications could be that you may owe more than what the estate has for value. That can be a very tricky situation, and it can be very difficult for the executor to have to manage that. Once everything has been paid and all the creditors have been assigned, then again, just like every other estate, it'll be up to the executor to close the estate. Now, in some jurisdictions, they require you to file the final accounting with the courts. I'm not aware of any jurisdictions in Canada that require that, but again, I'm not a lawyer and I'm certainly not in every province. So make sure that you are following the laws in your jurisdiction. But one thing that is important to do is to be sure to get that signed release letter from the heirs and beneficiaries, which will protect the executor from any future liability or any action on behalf of the heirs or beneficiaries once they've signed this release form stating that they're satisfied with the accounts. So let's back up. That's what happens if somebody has been successful in petitioning for the executor role with the courts if you have passed away intestate. What happens if you haven't got anybody that is going to step up and become your executor? Well, as I mentioned earlier, then the public guardian will become the executor of your estate. What that means is that they will have to track people down who are in your family and see if anybody would be willing to take on the role of executor. If nobody will step up, then that means that that particular jurisdiction is going to handle the closing of your account, all of the distribution, everything with your accounts. They will have to take on that role. It might seem simple to some people to do it that way, but in reality, you may end up having your assets distributed in a way that you did not want. If you had an ex-spouse, or if you had a child that for whatever reason you didn't want to include, the province, the court, the jurisdiction will not see it that way. They will follow the rules of distribution, and typically that follows the spouse and then the children, then the parents, and then they'll go to further relatives. If they can't find any close relatives, it could end up going to second or third cousins if they can track them down. So the way to avoid this is really very simple. Just make sure that you've done a will. Make sure that you are protecting your friends and family. Make sure that you're protecting your estate and your legacy from all of this confusion, all of this stress, all of this extra cost and trouble by simply doing a will. A will is not that expensive to do. You can go online. There are online kits where you can create your own will, but I will caution you that if you do that, it would be well worth your money to have a paralegal or a lawyer review it to make sure that it has been executed properly. Another way to guarantee that you are going to have your will declared invalid is to have it not executed or not created properly. And if that happens, you may as well have not had a will. So unless you have a lot of money and a lot of assets, most estates, most wills are not that complex, and most lawyers will create a will for a reasonable price. And often what they'll do is they'll package that into your estate planning documents, which will include a power of attorney document and a medical directive as well, which are topics that we'll come up with in another video. But for now, just be aware that the easiest and simplest way to make sure that your wishes will live on and that your legacy and your estate will be distributed the way that you want it to be distributed is to take action and make sure that you've created that will. And remember that once your will is done, it's not a one and done thing. That will needs to be reviewed, and it needs to be updated anytime that there are any big life changes. Has there been a death in your family? Has there been another child born? Has anybody had a divorce? Did you win the lottery? Anything that has made a substantive change to anything in your life circumstances needs to be updated in your will in order to make sure that, again, that it's current at the time of your passing. So I'm going to leave you with that today. I would like to thank Tom very much for sending this question to me. I look forward to answering some other questions in our upcoming videos. If you have a question that you're wondering about legacy and lifestyle planning or about estate administration, please just pop it in the comments here, or better yet, hop over to my website and fill out the contact form with your question there. Thanks very much for joining me. We'll talk to you again next time. Bye for now.